Someone has died, and there is a need to get the property from the person that died to the family. How do we do this? Hi, I'm Darren Findling of the Probate Pro, and we're going to cover the topic of conveying real estate from a person that has died to the family. The first thing we always want to understand is how the property is titled, how it's owned. So we look at the last deed recorded at the Register of Deeds, and we identify whether the property was only titled in the name of the decedent. If there's a joint owner on that property, for example, husband and wife, or two people as joint tenants, the survivor takes without the need for probate. Also, if there's a life estate and there are named beneficiaries on a deed, that also goes directly to the beneficiaries without the need for probate. But in the very common set of circumstances where somebody has died and the property is titled only in their name, probate is required. And that probate process begins by filing paperwork with the probate court to establish a file at the probate court and have a letter of authority issued to give a person the legal authority to act on behalf of the estate. That person is called the personal representative. And we look at that personal representative letters of authority to determine whether they have no restrictions or whether they are restricted for the sale of real estate. That's step one. If there's a restriction for the sale of real estate, when the time is right to convey the property from the estate to the family, a document must be filed, a petition, seeking the authority to do so. And I've covered that in other videos. That court order then would give the authority for the conveyance to the devisees or heirs at law. On the other hand, if it's an informal administration and there are no restrictions on the letters of authority, then the personal representative can use a fiduciary deed to convey the property from the deceased estate to the family. There's no form for the fiduciary deed. These are drafted by usually attorneys, and it conveys the property from the estate to the devisees as set forth in the will, or if there's no will, under the laws of intestacy, distributed to the heirs at law. That fiduciary deed gets recorded in the Register of Deeds and gives proof that the conveyance has occurred from the estate. Now, you can't do that until the probate has been fully administered, meaning the time is right for that conveyance to occur. And that's usually after the publication and notice to creditors and all of the exemptions and allowances have been resolved. That's usually the time frame upon which the estate is conveying the property to the family. So there's a lot of steps here. A lot of steps. Let's recap. First, identifying how the property is owned, then establishing a probate estate and appointing a personal representative through the probate court, and then identifying whether it's formal administration with a restriction on the letter of authority or informal administration with no restriction and the ability to issue a fiduciary deed. As you can see, probate is just not an intuitive and simple process, so we strongly urge you to work with a skilled, competent probate practitioner to guide you through this process. You can reach us here at the Probate Pro at 833-PROBATE or visit us at theprobatepro.com.